Hi, hello, welcome back to my channel. Today topic is Indian Constitution Part 2. 31 March 2002, however, recommendation of first report had not been accepted by consecutive government. Government India established term-based law commission recommended legal reform facilitating rule of law. Limitation. Keshavananda Anand Bharati v. State of Kerala Supreme Court ruled amendment cannot destroy Bar 6 modify it cannot be tinkered with the constitution basic structure framework which are immutable. Such amendment bill declared invalid although no part of constitution protected amendments basic structure doctrine does not protect any one provision constitution according to doctrine of constitution basic future when read the whole cannot abridge or abolish basic future have not been fully defined by whether particular provision constitution basic future decide court. Keshavananda Anand Bharati v. State Kerala decision laid down constitution basic structure supremacy of constitution republic democratic form government secular nature separation power federal character implies that parliament can only amend constitution to limit basic structure. Supreme Court, High Court may declare amendment null and void. This violated after judicial review. Typical parliamentary government where judiciary check parliamentary power. 1967 Golaknath v. State Punjab decision Supreme Court ruled that state Punjab would not be restrict any fundamental rights protected basic structure doctrine extend land of ownership practice provision and the case where considered fundamental rights ruling was overturned with ratification of 24th Amendment 1971. Judiciary final arbiter of constitution duty mandated by constitution. It acts watchdog preventing any legislative executive from overstepping constitution bounds. Judiciary protects and fundamental rights of people enshrined in the constitution infringement by any state body balance conflicting exercise power between the central government and state or states. Court are expected not remain unaffected pressure except other branches of state citizen interest group. Independent judiciary has been held basic future constitution which cannot be changed by legislature. Executive Article 50 Constitution provide that state must be take measure to separate judiciary from executive public service. Judicial review was adopted by the Constitution India from judicial review of interstate Indian Constitution. Judicial review dealt with the Article 13 Constitution supreme power of the nation govern all law according to Article 13. All pre-constitution law they conflict worldly and part of constitution shall have by alpha conflicting provision deemed ineffective until amendment constitution and conflict law will again come into force of compatible with the constitution amendment. Doctrine eclipse law made after adoption of the constitution must be compatible with the will be deemed void ab initio. Such a situation Supreme Court High Court determined law of conformity with the constitution such as interpretation not possible is not possible because inconsistency and where separation possible provision which is inconsistent with the constitution considered void. Addition Article 13 Article 32 226 and 227 provide constitutional basic judicial review. Due to adoption 38th amendment Supreme Court was not allowed preside over any law adopted during state emergency which infringe fundamental rights under Article 32 right of constitutional remedies. 42nd amendment void Article 31C added Article 368 of 4 368 of 5 starting any law passed parliament could not be challenged. Court Supreme Court ruled Minerva Mills Union Indian and judicial review basic characteristics constitution overturning Article 368 of 4 368 of 5 and 31C. Executive Chapter 1 Constitution of India create parliamentary system prime minister into practice exercise and most executive power prime minister must have been support majority of member by Lok Sabha lower house of parliament. Prime minister does not have support majority. Lok Sabha can pass motion no confidence removing prime minister from office. Prime Minister is the member of parliament who lets majority party of coalition comprising majority prime minister govern which aid council minister which prime minister appoint whose member head by ministry of importantly Article 75 established council minister shall collectively responsible house of the people Lok Sabha interprets article to mean entire council minister can be subjected no confidence motion succeed entire council minister must resign despite Prime Minister exercising executive power in practice. Constitution bestows all national government executive power in office of President. De jure power is not exercised reality. However, Article 74 requires President follow aid and advice council headed by the Prime Minister. Practice mean that President role mostly ceremonial with the Prime Minister exercising executive power because President obligated to act on Prime Minister wishes. President does retain power as council to reconsider advice. However, an action President may take publicly council it not required make any change before resubmitting advice President, which case President constitutionally required adhere to overriding President discretion of previous President have user occasion make public statement about the reasoning sending decision back to council attempt to sway public opinion system with the executive who only possesses nominal power and the official advisor who possesses actual power based on British system and the result colonial influence Indian before during writing constitution president chosen by electoral college composed member of both national and state legislature. Article 55 outlines specific electoral college. Half of the vote electoral college are assigned state representative in proportion of proportion each state and the other half of assigned national representative voting conducted by using separate single transfer vote. While constitution given legislative power to two house parliament article 111 require president signature bill become law and just with advice council president can refuse to sign and send back the parliament but parliament can turn into send back in the president who must be sign it. Dismissal of prime minister despite president mandate obey advice prime minister council article 75 declare both shall hold office during pleasure of president. That means president constitutional power to dismiss prime minister council anytime. Prime Minister still retain majority vote in Lok Sabha. However, good trigger constitutional crisis because some article constitution state council minister responsible to Lok Sabha must combine majority in practice usage has been whenever arisen through President Zail Singh threatened to remove Prime Minister Rajiv Gandhi from office 1987. Presidential power to legislative. When either or both house parliament not in session, Prime Minister acting via President can unilaterally exercise with the legislative power creating ordinance that have force of law. These ordinance expire 6 weeks after Parliament reconvenes or sooner. Both house disapprove constitution declare ordinance should only be issued when criticism arise require immediate action because the term not be defined. Government have begun abusing ordinance system enact law that could not be passed. Both house parliament according to some commentators appear the more common with the divided government when the prime minister party control lower house of north. Upper house ordinance can be used to avoid needing to approving opposition upper house. Recent year around 10 ordinance have been passed annually through peak of these years. Over 30 were passed single year. Ordinance can vary widely or the topic. Recent example ordinance include items were varied as modification land owner rights, emergency response, COVID-19 pandemic and changes banking regulation. Federalism. First article constitution declare Indian Union state under the constitution. State retain key power themselves have strong influence over national government via Rajya Sabha. However, constitution does provide key limit their power to give final say in many cases. National government state power in constitution Rajya Sabha at the union level of state representative in Rajya Sabha. Council of State the fourth scheduled constitution lays out number of seats each state control council state. They are based on roughly or each state population. Member of each state legislature elected and appoint these representative council. State most topics Rajya Sabha co-equal lower house. Lok Sabha concern required bill of become law. Additionally, as one of the house parliament, any amendment constitution record 2/3 of majority Rajya Sabha go into effect of provision of allow state significant impact of the national politics through representation in the federal chamber. State list. Constitution provides state with the long list power excluding their jurisdiction. Generally only state legislative capable passing law implementing these power union government prohibited from doing do. These power contained a second list 7th scheduled constitution known state list area state list wide ranging including topic like public health order and variety of taxes. State list grant the state control over the police healthcare agriculture election and more. Power can only permanently removed from state list via constitutional under amendment approved majority state. Rajya Sabha is the representative of the state can be temporarily removed. Item from state list under Union Parliament can legislate on it is. This record 2/3 of vote last of the renewal 1 year period. Amendment. Addition exerting influence over the amendment process via Rajya Sabha. The state are sometime involved in the amendment process. Special entrench process triggered when amendment constitutes specially concerned state by modifying the legislative power reserved by state 7th schedule. When this occur, amendment must be ratified majority state legislation of amendment to go into effect. Limitation state power. Union and concurrent list. While state list mentioned above provides power state other two other seventh schedule that generally weaken them. These are union and concurrent list. Union list counterpart state list containing area exclusive jurisdiction union government where the state prohibited from legislating item. Then union and list include national defense and international relation, immigration, banking and interstate commerce. Final list, concurrent list, which is contain topics which is both union and state level governments may legislate on. These topic include counters and criminal law and courts, union, social security, education and general. When the union state law concurrent list into item conflict of union level laws prevail, the only way of state level and law to override national one with the consent president acting the advice of prime minister. Additionally, any power not on any three list are reserved the union government and not for the state. Appointment governor. Governor of each state given the executive power respective state constitution. These governor appointed directly by president and central government because prime minister act via president. Prime minister in the who choose the governments in the practice. Once appointed governor server, a 5 years term can be replaced president at any time asked to prime minister and because union government can remove governor at any time possible that governor may act way of union governments want to deterrent and their state though can maintain their office. It has become the large issue state legislature after control different parties and union prime minister unlike early age constitution example governor have used to stalling tactics and delay giving their asset under legislation that union government disapproves. General influence union state politics and government limited. However, the fact that governor must listen to advise chief minister state who needs to command majority state legislature, they are key of where governor does not need to heed advice chief minister. For example, governor can send bill to president consideration instead signing into law. Creation state. Perhaps most of direct power over state union ability unilaterally and create new states out of territory existing state and modify diminish boundaries of existing state to be. Parliament must pass simple law with no super majority requirements. State involved do not have say outcome of state legislature must ask to command. Most of recent state created was Telangana in 2014. More recently, Ladakh was created as new union territory after being split off from Jammu and Kashmir in 2019. Daman and Diu and Dadra and Nagar Haveli were combined into single union territory 2020. Farmer was particularly opposed to some Arundhati Roy at the opinion of Jammu and Kashmir full state and legislation created Ladakh stripped area status of as a state and downgraded union territory allowing union government directly control required no input from Jammu and Kashmir. Federalism and courts. While the state have separate legislative and executive branch and share the judiciary and the union government, these different from other federal court systems such as interstate where state court mainly apply state law and federal court mainly apply federal law under the union constitution of Indian constitution. High court of state and directly constituted national constitution and the constitution also allow state to set up lower courts under the control by state high court or cases here that the appealed by high court and can be further appealed by Supreme Court. India's some cases all cases whether dealing with the federal state law move them same judicial hierarchy creating system sometimes termed integrated federalism. International law constitution including treaty making as part of executive power given to president because president must act according to advice council minister prime minister chief party responsible for making international treaties in constitution because legislative power rests with the parliament. President's signature international agreement does not bring it into effect domestically or enable court enforce provision of Article 253 of the Constitution bestows these power Parliament enabling make law necessary for implementing international agreement under the treaties. This provision indicates that the Constitution India's dual list of treaty law and only takes effect of when domestic law passed using normal process and incorporate into domestic law. Recent Supreme Court decision have begun change to convention incorporating aspect international law without enabling legislation from Parliament. Gramophone Company India Lit Birendra Bahadur Bandi court held the rule international law and incorporate national law considered part of national law unless the conflict with the act parliament essence implies international law applies domestically unless parliament say does not decision move Indian constitution more hybrid regime and but not fully monist one. Flexibility according to Granville Aston Indian constitution first foremost social document and aided by part of 3-4 fundamental rights and directive principle of state policy respectively acting together chief instrument and conscience of realizing goal set of the all the people constitution has deliberated been the one worded generally not vague of terms and ensure flexibility. John Marshall, fourth Chief Justice of Interstate, that Constitution great outline should be marked important objective designated under the minor ingredient which is composed. These object introduced from nature of objective themselves of the A document and intended to ensure age to come to must be interpreted not only based on intention, understanding framers and but existing social political context of the right life guaranteed under Article 21A has been the expanded including number of human including right to speedy trial, right to water, right to earn livelihood, right to education. Conclusion his book Making India Constitution retired Supreme Court Judge Hans Raj Khanna wrote Indian Constitution our heritage bequeath used to our funding father less are we people India trustees and custodians value which is pulsate within the provisional constitution it not parchment and paper a wave of life has been life of the eternal vigilance of price liberty and the final analysis only keeper are the people. Translation into Indian language Constitution Indian translate into only few 22 official language of Indian Republic. Bengali translation Constitution India was first translated from English into Bengali language and published 1983 as the Kolkata through collective effort of Governor West Bengal Union Government of India. Second edition was published 1987. Third 2022 contains up to 105th of Amendment Constitution. Meitei translation not to be confused Manipur State Constitution Act 1947 or Constitution Meitei Civilization. Constitution India was first translated from English Meitei language officially known as Manipur language published on 3 January 2019. Impaled through the collective effort of Government Manipur Union Government India was written Bengali script contained of 95th Amendment of the Constitution. Translation project was started in the 2016. Director of Printing and Stationery Government Manipur on 19 November 2023. Nangtam Biren Singh and the Chief Minister of Manipur declared that will translated Meitei make digital education and edition of the 26 November 2020. Nangtam Biren Singh, Chief Minister Government Manipur officially released at Dialect edition Constitution of India Meitei Mayak Manipur language and English as the Cabinet Hall CM Secretariat and Impal part of Constitution Day celebration National Law Day Republic of India containing up to 105th Amendment of Constitution first time history was made to be available all education institutes government office public libraries across Manipur state. Odia translation Constitution of India was first translated from English into Odia language and published 1 April 1981 Bhubaneswar through collective effort of Government of Odisha and Union Government of India. Sanskrit translation. Constitution of India first translated from English into Sanskrit language and published on 1 April 1985 as New Delhi. Tamil translation. 4th edition Constitution of India Tamil language was published 2021 Chennai through the collective effort of the Government of Tamil Nadu. Union Government of India contains up to 105th amendment of the Constitution. Thank you.